And I think what you've said is actually the perfect segue in looking for other examples from around the world. Some good practices from Latin America. But before we get to the good practices, Elena, let me ask you a little bit about the not so good practices on the other side of the continent, on the US side. We've heard that there are still some employer-tied visa systems in the US that are very much alive, and they are operating maybe under different circumstances. But can you give us an idea about what are some of the issues within that particular context, but also how has civil society moved on this issue? Is there anything for us to learn from how you guys have been also operating on this? And then going back to the example of Latin America, why is it so different in Latin America? How can we get there? To you, Helena.
Well, thank you. Thank you, Rula. I would like to start by expressing my gratitude to MFA for the invitation to be here today. Congratulations, you have an incredible audience. So I'm really glad to be able to speak to a different audience, and I appreciate learning from the situation in other parts of the world. I also would like to acknowledge from the beginning that what I'm going to build on many of the comments from my predecessors on this panel, because I think that all of them made important contributions to where I'm hoping to get here today. So I think that there are a number of issues that have been said before that I will build on them towards my conclusion. I would like to describe briefly the system in the US, then jump into Mexico, and then move south to Argentina, and finalize with the discussion of the current migration law in Chile, because I think that it illustrates the difference in the panel. So the US immigration system very much has these categories of migrant workers with very different rules and regulations. It's in essence a discriminatory system. The more education, the more wealth you have, the different treatment you receive. Less education, less wealth, the unskilled worker, then the less rights and power you have in that relationship. And that's the first thing that I want to present today. Perhaps we need to revisit this idea of the skilled and the unskilled worker. It's a concept that economics has brought to us and that we have accepted and we use. But there are specific skills in agriculture. There are specific skills in all kinds of labor. So perhaps that's one first element that I think that we need to move ahead. But in the US, they have come up with these different categories. I want to underscore this exception, which are persons of what they call extraordinary abilities. So these are people in the science, in the arts, in education, business, athletics. Perhaps if any of you likes basketball and you're watching the NBA, those foreign players fall into this category. Persons of extraordinary abilities do not even need an employment offer. They can acquire an employment visa simply based on their abilities. And I think that's important to underscore. And then we fall onto these categories of professionals holding advanced degrees. And this, of course, many of these jobs are jobs that end up in the academia. Then we have skilled workers also with professional skills. And then we move on to certain special immigrants. And this is an interesting category because this is kind of a bag where they put together ministers from different religions. They have included, and this is interesting, a small number of Iraqi and Afghan translators, for instance, who were working for the US forces, and they cannot continue living in their countries due to safety reasons, so they don't apply for asylum, but there is a small quota for them to come to the US, correct? There's also workers from the Panama Canal to reward them when the Panama Canal was under US administration. So they can migrate to the US based on this category. And I find that very interesting, as well as NATO civilians, okay? So this is a very peculiar category. Under these categories, the employer must demonstrate that the person is needed in the US, and then the person can travel for that worker visa. But definitely it's a different category. It's also very important to underscore that from this category, these are what in the US are called immigrant categories, meaning that you can enter the country under this visa and then apply for a permanent visa. That means living long-term in the United States. And this is a very complicated division that many countries have, and no one has underscored as much as I would like to. And it's this idea that there are this category of workers which are very much disposable. They are needed by the economy, but when they are not needed, they have to turn back. We are asking hundreds of thousands, millions of workers to be willing to work abroad with no expectation of on their own life projects. It's only a way for them to acquire a wage, but they cannot think long-term of moving with their families, of living long-term in that other country. So we are asking these millions of people to live lives with a temporary kind of vision of their lives, when the rest of us may have the luxury of projecting ourselves and thinking that perhaps where we are is where we would like to stay a longer period of time. And I think that that's also something very important to underscore. Then in the US, we move into these other categories, which are like, then there is the H-1 visa, which is temporary employment. And this is a very interesting category because this is a category for individuals with a university higher degree. And these are the type of workers that we see in the tech industry in Silicon Valley in the United States, science, engineering, information technology workers, correct? Teaching, accounting. And this is interesting because this type of visa has a quota, and there are intermediaries who are immediately applying for those number of visas and then reselling them, correct? So we have intermediaries, not only in the unskilled visa categories, but also in the highly skilled categories. Then we go on to H2A, which are agricultural workers visas, and then we have H2B, which are non-agricultural workers visas. These are essentially temporary workers visas. In both cases, the maximum amount of time that they can remain in the country is for 3 years. They are tied to one employer only. And if they dare to complain about their working conditions, definitely they will fail, they will suffer the repercussions of that. At any point, the employer may decide to terminate that contract and that person returns to the country. In theory, they should not be charged for any fees. But what we know in practice is that the recruitment agencies in the countries of origin are charging them fees to be able to apply for those jobs. They have to go through a visa interview process, and then they are also charged to be accompanied to the US consulate to apply for the visa, for instance. They are charged all the way through the process. They work, they should not dare complain, and then they are returned back to the country of origin. What is interesting in the context of COVID-19 was that there was a specific shortage of agricultural workers, and so the US was faced with the need to extend the visa of those agricultural workers that were already in the US because they did not want agricultural workers to be coming at that time for the fear of bringing more cases of COVID into the United States. So I think it's an interesting system in which workers are basically unprotected, and we see great differences. Now, when we move then down South America, what we observe in most countries is the idea, again, that you are only employed if you have a working relationship. You need a contract to apply for a worker's visa originally. And that's the requirement, for instance, in countries like Mexico to enter the country. If you do not have that contract, you are unable to acquire the visa. And that, of course, it's a great problem. Only if you have a family relationship with a Mexican national, you can apply for a worker visa once you are inside the country. And that, of course, creates great problem because we have to acknowledge that a pragmatical approach works much better. That individuals sometimes travel without a job relationship already established, but they hope to get one. And in many cases, they find jobs. So some countries have rather changed to a more pragmatic approach, allowing individuals to enter the country with any visa, kind of like a tourist visa, and then inside the country, applying for a worker's visa. And of course, if you are negotiating inside the country, a migrant worker is very much at the same situation as a national worker, probably not the same because the employer understands that they need the visa. So that's an element in the relationship, but they are better off than when you are hired abroad. that is probably when workers are at the weakest in terms of the power relationship. And that is what other countries have done. That is the model that Chile used to have some years ago. And that is the current model that Argentina has, a very pragmatic model. You come into the country, you found a job, then you apply for a temporary worker's visa. And they use the definition of a migrant worker of the Migrant Workers Convention, which I also think it's remarkable about the Argentinian legislation. I think it's quite progressive. To finalize, what is going now in Chile is that they are having a discussion to review their immigration legislation. And they claim that immigration can only be safe, orderly, and regular, as the compact calls it, if you apply for a worker's visa from abroad. Okay, they want to move into the model of the consular visas, which is very much the model that I described in the context of the US. What we know in practice is that that is not the reflection of migration, that many individuals enter the country and then they find a job. So if the desire is really to have safe, regular, and orderly migration, a pragmatic approach is definitely the most important one. Finally, I want to underscore a couple of concerns, and it's whether in some countries workers are able to change employer. What Elizabeth just mentioned, the ability for the worker to work with one person and then perhaps they find someone else where they are treated better, or their wages better, the working conditions improve, and they want to move to that other job. In many visas in the United States, you are tied to that employer. And I think that that's something that we really need to fight to eliminate everywhere in the world, to give greater freedom and protection to employers. The second, and probably the most important vulnerability that we observe in the US, is the consequences that workers face when they file a lawsuit, when they complain against their employer. In many countries, what we are observing is that employers are denouncing their workers immediately to the immigration authorities, and workers are being apprehended for deportation when they are in court, filing lawsuits, in the middle of labor cases against their employers. And I think that that's an atrocity that should not be taking place, and which should ensure some basic protections for workers. So when a worker files a lawsuit against their employer, they should immediately be granted some kind of immunity for immigration enforcement until that case finalizes. Otherwise, even if in the remote possibility that the worker wins, that worker will also struggle even to obtain back the wages that they were not paid to them or any other amount. So I think that that's a second element that I want to bring. The recruitment fees are a big challenge. I think that not enough is being done. I know of the ILO efforts to try to work on this issue, but I do think that there has to be greater coordination between the countries of origin of the employers and the countries of destination. Many of the fees are being actually charged at the country of origin. There isn't enough supervision, and more could be done in that regard. Finally, I want to bring to the table the portability of benefits, because we also have to understand that many of these workers are being deducted part of their wages, and they're contributing to the social security system of countries where they are not going to retire, and they are unable to take those savings, their own contributions, back to the country of origin. And I think that that's a final element in which we all need to continue working. There are some efforts in South America which I think are very promising as a result of agreements, and we should be able to move ahead. I think this is a very interesting and energizing discussion, and I thank you for the opportunity to be here. Thank you.
Thank you, Helena, for this great overview of what works and what doesn't work. And I think as you call early on, we need to relook at this distinction, or as Elizabeth also puts it, discrimination between the skilled and non-skilled worker. One thing that caught my attention really was how you talk about this visa conversion. So you can enter on a tourist visa and then convert your visa into a work permit that exists and works in some parts of the world. I know, at least in this part of the world, sometimes this is also, again, taken on to say, how do we ensure that countries of origin also know that their nationals are abroad and that they get access to consular protection, which also kind of raises another set of questions. But it's interesting to know that it is working, and it can work in one part of the world. And I think just gathering from our discussion, we've had some interesting ideas about, what's next. Obviously, we all know there is a problem here, but what's next? And then, Helena, you say critically and crucially the need to be able to change employers. We've also heard ideas about people coming in on an employment category as opposed to people coming in attached to a particular employer. So I think we've kind of covered a lot since we started.